One of the best employees I ever had been fired from the state court administrator's office because she thought she was sending a racy joke to one of her friends, and instead she sent it to the entire email list. All of the Supreme Court justices, all of the judges, everybody. Think before you sin. Jessica knows when we were making public records requests right after Governor Scott took office, I was requesting all of the email correspondence of the 5 top staffers. I was doing this as a favor, believe it or not, because they were being overwhelmed with public records requests. And the Office of Open Government just had 2 people. And everybody wants the email correspondence. So I stupidly said, I'll do it. It was a nightmare. I had to do a spreadsheet because I did part of it this time, part of it this time, part of it this time, this time, this time. I think the last chunk I got was about 6 months after I had made the request. I ended up spending hundreds and hundreds of dollars, 1 week's worth of one staff member's emails, $789. 1 week. But one of the things we saw was an email from one of the top advisors to the governor, and in that email she said, please don't use my .gov email address, use my private email address, and I'm trying to avoid the public records law. Yes, sir.
Okay, I don't know if you're aware of,
And to speak.
I don't know if you're aware of e-discovery or predictive coding. That would have cut your search time significantly on emails.
Well, I'm not searching for it, I'm just trying to retrieve it.
No, I know. Well, the point is, in order to retrieve it now, there are programs,
Right.
software programs that,
And there are software programs to redact, and there are software programs to capture and index text messages. There's no incentive for government agencies to do this because they're passing the costs on to us.
except that courts have found that they can be held accountable for.
Not yet. In
Yeah.
terms of fees, they're not there. We're still dealing with the fees.
Okay, well.
And there have been recommendations for the use of these softwares. There have been recommendations that the agency shouldn't be able to charge us for the cost to redact. But until the law changes and until they have some incentive, and as long as they can pass those costs on to us and obfuscate and delay our right of access, we've got problems.
Okay.
It's just a mess, and I have seen some of those softwares that are just phenomenal.
Yeah.
Orange County, after TextGate, did get software that allows it to automatically track text messages. And Dave Dameron told me where it took him weeks or months to get text messages before they had that email. Once they got the email, is Dave here, by the way? I've never met him, I just talked to him on the phone. It took a question, it was a matter of minutes.
Exactly.
Yes, did you have a question?
Yeah, what format do they provide emails to PST files?
PST, one trick I learned was to ask for public records in their native electronic format. Native electronic format. If you ask for them in an electronic format, they can give you a PDF. And a PDF is not the same. And we'll talk about that for public records. That phrase, native electronic format. If you can't open it, you can find somebody who can. Okay. So, Sunshine Law, single board members. This was a case down in the Estero Fire District where the fire board appointed one member of the board to negotiate a contract on behalf of the entire board. He did not have the authority to bind. He couldn't sign the contract, but he could accept or reject offers. And the court said those negotiations were subject to the sunshine law. There's now a limited exemption in the law for competitive solicitations, but it applies to competitive solicitations only. No single source contracts, no bid contracts. Competitive solicitation only. Members elect, as I said, this is really Transition teams appointed by a member or officer-elect are subject to the sunshine law because they're making recommendations. This is where Governor Scott got in so much trouble early on. They destroyed all of the transition team emails. And I don't mean deleted them, I mean laser scrubbed, 4 times destroyed. They were not retrievable. He was unaware that his transition teams were subject to the sunshine and the public records law. And to his credit, he made huge attempts to get those transition team emails. He went to all the members of his transition team and asked them to send it. He was able to retrieve about 50,000 emails. And he asked the legislature to amend the law to make it clear that members and officers elect are subject to the sunshine law and the public records law, because we were relying on Attorney General's opinions and case law prior to that. But now Chapter 119 and Section 286.011 specifically include members and officers elect. So when does the sunshine law not apply? Fact finding. An advisory committee created for the purposes of gathering facts. They're not making a recommendation, they're just fact finding. Sunshine law does not apply. So with their presidential search, they're just gathering applications, they're checking references, they're putting them in alphabetical order, they're making sure that all the required documentation is there. No recommendations, no ranking of candidates. Fact gathering only. Sunshine law will not apply to the committee created for the purposes of fact finding. This is very important. The fact finding exception does not apply to the collegial body with ultimate decision-making authority. So our school board can create a committee to gather information about closing schools. But if that committee is going to make a recommendation based on which school should be closed, the committee will be subject to the sunshine law. And the school board cannot legally fact find. This case kind of surprised me because remember that we said the sunshine law applies to discussion between 2 or more board members. In the Finch case, they put all the school board members on a school bus and sat them rows apart so they could not discuss school board business. And everybody swore nobody discussed school board business. They had the school board attorney on there, they had the school board superintendent on there, and they had an expert giving information to the members of the school board as they drove around looking at potential school sites. One school board member asked one question, no discussion whatsoever. The court said that was a violation of the sunshine law because the public wasn't there to hear what the expert was saying. That should have been a workshop open and noticed to the public. So even though there was no discussion whatsoever, the court said it was a violation of sunshine. And the school board, the collegial body, cannot fact. It really surprised me. I thought it was a dumb case. And then we have to square it with this. Political forums organized by a private organization, such as the League of Women Voters, you're doing that all over the state right now, are not subject to the sunshine, even though we have the entire county commission and their challengers sitting there discussing business and issues or issues on which they're going to take action. Sunshine law doesn't apply. But it has to be sponsored by a private organization. You can't have a commissioner organizing a community forum and inviting the other members of the commission. That's a meeting subject to the sunshine. He can do it, but he's got to provide notice and he's got to take minutes. I'm gonna start getting questions about walking town halls and all, I mean, a walking town hall in and of itself doesn't violate sunshine, but how are we gonna make sure that all discussions are audible, that everybody can participate, that they can talk if they want to talk, and who's gonna take minutes if you've got 6 commissioners walking in 6 different directions? I'm not sure how it works. Apparently, it works quite well in New England, but I don't think it translates forward. Sunshine law does not apply to social gatherings. Members of the same board or commission are allowed to socialize with one another. They can't talk about public business. I had a question yesterday. One city commission routinely meets at the same restaurant prior to every commission meeting. They claim it's a social event. Citizens have a right to go up to them and ask what they're talking about. If they say the golf game and the discussion, but this guy yesterday said we always make sure we get a table as close to the commission as possible. They're allowed to socialize. They just can't talk about board business. And their attorneys should be warning them on a regular basis and reminding them, don't step over the line. You could be talking about, the golf game, and then all of a sudden you start talking about the Parks and Rec schemes. Be very careful, because it's a very fine line. So notice. Notice must be sufficient so as to inform. That means it has to be reasonable in terms of content. You do not have to include an exact agenda in the notice, but there should at least be a summarization of the issues the board intends to discuss. An agenda is not required. It has to be reasonable in terms of timing. The first Tuesday of every month, 10 days notice, publication in the Orlando Sentinel, the newspaper of widest general circulation. Or it could be that, you've got the IT committee on purchasing, new platform is meeting, and that could be subject to sunshine, but it could be that you could just put notice on the agency's website. That could be reasonable. It's going to be reasonable under the circumstances. You should note, however, that there are other statutes, codes, and ordinances that impose different and more stringent requirements. And some of the exemptions to the sunshine law are much more stringent. This is the basis. This is the floor, the minimum standard. This is for your first Tuesday of every month school board meeting. If they're talking about something more specific, they may have other more stringent notice requirements. State agencies are subject to the Administrative Procedures Act, Chapter 120, that lays out very strict guidelines for how you must provide access. So the type of notice will be variable depending on the facts, and the purpose is to inform the public. The sole purpose of notice is to inform the public. All right, this is the most contentious issue in the state of Florida. I thought we had fixed it, but we haven't. Mr. Smith wants to speak. Does he have a right to talk? He does now. Back in 1969, 1 year after the passage of the Sunshine Law, the Florida Supreme Court said that the public has an inalienable right to be present and to be heard. A few years later, the Supreme Court said, well, maybe it's not that inalienable. And it said those meetings where the board is going to exercise its executive functions, you don't have a right to speak. But those meetings where they're exercising their legislative function, you get to speak. And that was interpreted as workshops where they're just gathering information and learning more about an issue, no right to speak. But those meetings where they're going to take votes, you have a right to And that was sort of the rule, as everybody understood it, until about 6 years ago. We had a case out of Pensacola. The city commission created a commission, the Maritime Commission, to make recommendations on spending millions and millions and millions of dollars improving the city's waterfront. They were operating under the rules of the city, which allowed everybody a reasonable opportunity to be heard. Well, the chair of that commission, who was a former federal judge, when the citizens started speaking, he physically turned his chair around and sat with his back to the audience. He didn't care what he had to say about how he was going to recommend the city spend your money. He didn't want people. And they passed a rule saying no public comment, the commission. They got sued. Slam dunk, inalienable right to be present and to be heard. The first DCA said, sorry, it doesn't specifically say you get to speak in sunshine. So you can go, but you can't talk. We had 2 more cases on the same issue. Everyone said the same thing. So the legislature responded. It took them 3 years, but they finally passed section 286.0114, which says boards and commissions must provide the public with a reasonable opportunity to be heard on propositions before the board. They have to let you speak before they take action. There are a couple of questions that have come up about this. How does this affect consent agendas? I love consent agendas. 16 items, 1 vote, we're done. Well, they can't pass a consent agenda unless they've allowed the public a reasonable opportunity to speak on each item on that consent agenda. The law says that the right to speak, the opportunity to speak, doesn't have to occur at the same meeting where action will be taken, but it must occur within reasonable proximity. So if we have a consent agenda that we're taking up on Thursday, we could hold a meeting the previous Tuesday and let everybody speak on all 16 items. Then that would be okay at the regular meeting to allow voting on a consent agenda. This reasonable proximity, a school board over in southeast Florida is considering closing a bunch of schools. It's really controversial. And they held a meeting to discuss the possible school closure. The county commissioners were there, the city commissioners from every city in the county, the parents, the teachers, the kids, everybody wanted to talk. We don't have time to let you talk. So we're going to schedule a meeting. Everybody will have the opportunity to speak, and then we'll schedule a later meeting where we're going to take action. So a week before the meeting where they're going to vote to close the schools, they scheduled a 3-hour meeting, gave everybody the right to speak. Not one school board member was present. That outrages me. I don't live in that county, and it outrages me. We vote these people into office to represent our interests, and they can't be bothered to show up. I don't know if that's a violation. It doesn't say that the board has to be there.
Is that challenged?
I just read that they haven't yet. That was at least a year ago, a year and a half ago, and they're meeting again this week to decide what schools to close. So, somebody, I mean, I certainly have thought quite a bit about it. I find it outrageous. I really do. I mean, there's a reason we call people who sit on this side of the audience public servants. They work for us. And we should have the right to tell them what we think about the job they're doing on our behalf. The law allows for the adoption of reasonable rules requiring orderly conduct and the orderly progression of the meeting. No shouting, no shoving, no kicking, no biting. It's hell. And for the orderly progression of the meeting, everybody gets 2 minutes, everybody gets 3 minutes. You know, there are 20 people over here who all have the same opinion. We're going to let you pick 3 representatives, and you'll each have 5 minutes. Opposing side, 3 representatives, you each get 5 minutes. When we had the Commission on Open Government Reform, Jessica was the staff person. We said anybody who wants to have a time certain on the agenda, let us know in advance, and we'll put you on the agenda, and you'll get 5 minutes. And then we'll have an hour in the middle of the meeting and an hour at the end of the meeting, and we'll divide that up among the members and the public who wish to speak. Nobody gets more than 5 minutes. I think one woman signed up 6 times for the same meeting, trying to get, as many minutes as she could. So we had to say, no, you only get signed up once. And then we would invite people to submit their comments in writing, then we could make them part of the record. And everybody, I don't think we had one complaint. And it did kind of stun me. I wanted a gavel. I was chair. I wanted a big gavel. We didn't have one. So we used little index cards to let people know when their time was up. And we would just flash that little card. And when you got to the end, you got a big 0. And I flashed the 0 card, and the woman who was speaking burst into tears. And, she was crying, and she said, thank you for being so nice. Nice? I guess she was used to being gavelled down. She was from Perry, Florida, and there was a big controversy at Perry at the time, and she was used to being gavelled down, and she was weeping because I just flipped the little card at her, so I told Jessica, no gavel. We'll just keep using those little cards because we were being nice. Mr. Smith starts criticizing, or Ms. Smith starts criticizing a member of the city commission during the time set aside for public testimony, but the commission has a policy saying you cannot criticize a member of the board or commission. Does she have a right to criticize? Yes. We can't criticize you? Agencies can adopt reasonable rules. Those rules have to be uniformly applied. A reasonable rule would be we're setting 15 minutes aside for comment on each agenda item. And when you're talking about, when you fit into that 15 minutes, you speak on the agenda item. But when it's open mic time, you can bring anything before your elected representatives that's related to the business they do. And if you have a criticism of the way a board member or a commissioner has done something, you have a right to say that. What are you supposed to get up and say, well, one of you did this? I'm not picking on, Pensacola and Escambia County. The city of Pensacola had just done something, passed some rules or ordinances about the homeless. They have a big homeless problem because the weather's nice, it's right on the water, it's right on I-10, they have a huge homeless problem. And they adopted some rules or ordinances, and at their next meeting, Father Monk, a monk, came and criticized them for their unchristian behavior towards the homeless. The chairwoman said, Father Monk, I find your remarks offensive, and I want you to sit down and shut up. Father Monk, who's in his monk's robe, that little robe belt, said, but I've got 3 minutes, and 2 minutes are left. And she said, I don't care. Either shut up and sit down, or we're taking you out of here. And there's wonderful footage of him standing there behind the microphone with his hands at his waist, with armed law enforcement officers surrounding him. For 2 minutes he stood there, not saying a word. And at the end of his 3 minutes, he sat down. Probably much more powerful than anything he could have said. He had a right to speak, even though he was criticizing. In Tallahassee recently, it was a big controversy when it was learned that the county or the city commission had installed a kill switch. Not, and somebody said, oh my God, they electrocute them. No. They turn off the microphone because there are a couple of very strong critics of local government, particularly the mayor, who get up and they take their time every time to criticize the mayor. And they may be being repetitive, but the fact is they have a right to say it. Well, the mayor, I guess, got tired of hearing it, and they installed a kill switch that allowed either the city clerk or the mayor to kill the mic. People went ballistic. Even though they didn't like this guy, they recognized that he had a right to speak. So rules must be reasonable, they must be uniformly applied, and they must be content neutral. You can limit comment to various items on the agenda, but there should be some open mic time. How does the commission know that the flooding in Lafayette Park has become such a problem that people's cars are floating away if we're not allowed to tell them? It is okay to remove people who have become disruptive. That is not a violation of their First Amendment rights. But if they're simply sitting there criticizing, and they're within their 3 minutes, there's not much you can do about it. Also, people are allowed to record public meetings as long as they're not being disruptive. Probably know there's a law in Florida that says you can't tape record a conversation if all parties to the conversation agree. That does not apply to public meetings. So agencies can't hold meetings at facilities which discriminate based on age, race, sex, economic status, that sort of thing, that unreasonably restrict public access. In Ocala yesterday, the question was about CDC's community development that hold meetings in gated communities. I might not live in that gated community, but it could be right next door to where I live, and I should be allowed to attend that CDC meeting. CDCs are subject to the Sunshine Law and the Public Records Law. And if they're going to hold a meeting at the rec center in a gated community, they better make sure that gate is up and everybody has the right to fully attend. Yes?
What is CDC?
Community Development
Corporation?
Corporation, or
Okay.
I forget what the second C stands for, but they're subject to the Sunshine Law. Also, agencies must hold meetings at facilities of sufficient size so as to accommodate the anticipated turnout. If you're talking about increasing the millage rate, which is happening in Marion County, they can bet there will be hundreds of people there. And they may have to move the meeting from county administrative building to the public library in order to accommodate the anticipated turnout. What I love is when the legislature has a meeting and they're going to be talking about something like merit pay for teachers, and there are thousands of people there, and they're holding the meeting in a room where 6 people can fit. They put TV cameras out in the hallway, which allows you to watch. It doesn't necessarily allow you the opportunity to speak, but that's okay, because what the legislature frequently says is, I know that there are 1,000 people here, you've come from miles away, you took time off from work to drive up from Miami. You can't fly to Tallahassee from anywhere in Florida without going to Atlanta. I know you've driven, you've taken days off, and we really appreciate your being here. We're going to take a vote on this bill, and after we take action, we'll stick around and listen to what you have to say. You just voted it out of committee. How do you know I can't change your mind? Well, we'll sit here and listen to you. You know, it's too late. We'll listen. I get a lot of calls. commissions, chapter 125, school boards, chapter 1001. They should be at public facilities where the public is free to enter. Complaint yesterday about a meeting where you had to go through security, you had to sign in, and you had to provide your ID. You can go through security, but they can't make you provide an identification to attend a meeting. Any questions?
I have a question.
On that one?
On the out-of-town meetings one. If a city commission, or say 30 members of the city commission, go to Tallahassee to lobby the powers that be that they want, sunrail or something about sunrail, this or that, that's a public meeting.
Yes, ma'am.
So it should be noticed
Yes, ma'am.
and there should be access.
Yes, ma'am.
It's not like you get to be told to make it back.
Right. We actually had, during the Bush administration, there was a big controversy. I think it was oddly Pensacola. The local commissions and counties and the delegation, the legislative delegation met with the governor to talk about issues. So it was their local, it was their state reps and their House and the senator, and then the city commission and members of the county commission and members. And a reporter went in with them, and she's wearing her reporter's badge. And I guess Jeb said some things that he shouldn't have said, not realizing that there was a reporter there. And she reported it, and she got excoriated by the Bush administration. She had her press badge on, and she was not an unfamiliar face in the Capitol. The fact that Jeb didn't see that she was there is not her fault. But yeah, they're supposed to be providing notice of those meetings. A lot of them do. And a lot of the attorneys will say, I don't care what it costs us, you have to ride in separate cars. We're not going to rent one car for you all because I'm worried to violate the sunshine law. That's not required. They're just not allowed to talk about public business. They can all go in one car if they want to. But yes, they should be noticed. And you, if you're in Tallahassee, or you want to drive up to Tallahassee and sit in on that meeting, a lot of times they'll do it locally. And I got a call about 3 weeks ago. The local delegation wanted all of the local government people to come to a meeting. And the question was, who provides notice? Well, the city commissions provide notice, the county commission provides notice, the school board. The legislature is not responsible for providing notice.
But, and the sunshine law applies to the lobbyists for the city as well.
Not necessarily,
Ah,
no. Because they might be negotiating on behalf of the city, but they can't strike any deals. No, I don't think the lobbyists are. They might be under some circumstances, but their meetings with legislators would be fun to try, wouldn't it?
yeah.
Also, there's a provision in the law, I don't have a slide on, state agencies are allowed to conduct meetings like teleconference meetings. Local governments are not. So they have to have a quorum of the members physically present in order to conduct a meeting like the sunshine law. Might be a violation if board members discuss business in a manner not generally audible, the leaning back in the chair going like this, or the piece of paper held in front of the face with the head turned like football coaches. It's not clandestine, but it violates the letter and spirit of the law. You'll hear us talking about the requirements of the law, and then you'll hear us talking about the spirit of the law. And a violation of the spirit of the law can be a violation if the courts say it is. All board members present at a public meeting must vote. They can abstain only if they think they have a conflict of interest. You can use written ballots to cast a vote, but those votes, who voted how, must be read into the record. And the ballots must be maintained, they are public records. So there's no secret votes. all meetings between 2 or more board members, we presume it's a meeting. That's why we get to go up to them when they're having lunch and politely say, what are you talking about? If they're talking about public business, we pull out the chair and we sit down. Only the legislature can create exemptions to the constitutional right of access. If a board is meeting to discuss records that are exempt from public disclosure, they can close the meeting only if there's a specific statutory exemption for the meeting. Economic development corporations have a public records exemption, but they do not have a sunshine open meetings exemption. So the Economic Development Board must meet in the sunshine to discuss secret projects. I hate that economic development exemption. We had a big argument with, I think it was the city of Orlando. There's an exemption under 288.075 if a private company wants to locate, relocate, or expand its business operation. The records are exempt if the private company requests confidentiality. They're exempt for 1 year, that can be extended, or until the information otherwise becomes public. The magic was negotiating with the city of Orlando to stay. This was years ago. The negotiations were successful. There's a huge billboard on I-40, I-4. Magic is staying. The Orlando Sentinel made a public records request for the records and was denied under the economic development. It's public. It's on I-4. We fought about that one. If denied access to a meeting, the person denied may demand a statutory citation. The burden is on the agency to tell us why we can't attend the meeting. And please, if you're denied access, whether to a meeting or to a record, ask for the statutory citation. You're going to call me and say, I was denied, I don't know why. There are 1,100 exceptions. I probably don't know why either. And the burden is on the agency, so get in the habit, if they say no, you say why.
What's the statute?
What is the statutory citation? And they have to give you the specific citation. They can't simply say, chapter 119, or section 286. They have to give you the, and then read it. It's really easy. Go to, I like the Senate's website, flsenate.gov. You have the current statutes right there. You put in the citation, it pops up, and read it. Because exceptions to our right of access will be strictly construed and narrowly applied. And some of these exceptions, as we're going to see, like this litigate, look at all of the exceptions. Pending litigation. There has to be a public meeting at which the attorney tells the board, I desire advice on the case of Barbara Peterson versus Orange County. Oh, don't tell them that, because they already think I'm suing them, and I'm not. City of Orlando. I'll get it in. That's all spelled out in the statute. And look at this. A court reporter must be present and must record absolutely everything that is said. Minutes are not sufficient. There has to be an actual transcript. If the city or the county or the school board violates any one of those, they let somebody in who's not allowed. The attorney asks for a consensus. That's action. They lose the protection of the exemption. They have violated the law, and the transcript becomes a public record now, rather than at the conclusion of the litigation. The security exemption allows closure of portions of government meetings which would reveal security systems plans. Security systems plans is defined in Chapter 119. It does not include IP addresses, which some government agencies have been arguing. Competitive solicitation, this is relatively new. The only thing that you really want to pay attention to is it applies only to competitive solicitation. If it's a no-bid contract, a single source vendor, that exemption does not apply and the negotiations are open. But the point of this is to protect the vendor's interests. If all of the vendors got to go to the meetings where I'm being interviewed, and my name is Allen and your name is Williams, and I go first and you go last, you have a competitive advantage over me. You can tailor your presentation based on my presentation. But it's a very narrow exception. Okay. The city commission violated the Sunshine Law by refusing to allow Ms. Smith to attend. What do? They hold what we call a cure meeting. Action taken at a meeting held in violation of the Sunshine Law is void ab initio, as if it never happened. So if the city holds a meeting held in violation of the Sunshine Law and fires 10 staffers, and a court determines that the city violated the Sunshine Law, those 10 staffers are unfired. The action is void ab initio. But if they hold a cure meeting prior to the determination by the judge, it could be after the suit is filed, they can cure the action. They have to hold a meeting in strict compliance with the Sunshine Law to the best of their ability, recreate the discussion held at the flawed meeting, and then take independent final action in the sunshine. Vote again. That will cure the action. That will ensure that those 10 staffers remain fired. But it does not cure the violation. They have still violated the law and they can still be sued for a violation. We had a case recently, again, this is the first time in my knowledge, where a city commission held a meeting in violation of the Sunshine. At that meeting, they hired a new city manager. They had to hold a cure meeting. They held a cure meeting a couple weeks later, went in, discussed everything all over again, took independent final action, so independent that at the cure meeting, they hired somebody else. No doubt that was independent final action. Any questions? So what happens to somebody who violates the law? Suspension and removal from office. We've had a city, I think it's a mayor down somewhere around Miami, who was removed from office for violating the law, and then on appeal, they said he didn't violate the law. So now he's petitioning the governor for reinstatement. Unintentional violations are non-criminal infractions punishable by a fine of up to $500. Intentional violations are second-degree misdemeanors punishable by up to $500 and no more than 60 days in jail. The only person who has ever gone to jail for an intentional violation of the Sunshine Law was from Escambia County. W.D. Childers, who got term limited out of the Senate, became a county commissioner, violated the Sunshine Law. He claimed that he was not discussing a crooked land deal with the other two commissioners. He was haranguing them. They couldn't get a word in edgewise, therefore it was not a discussion for the purposes of the Sunshine Law. He went to jail for 60 days for intentional violation and then served another 10 or 12 years for other problems. Attorney's fees and court costs. It might be a $500 fine, but if you violate the Sunshine Law, I sue and I win, you have to pay my attorney's fees and court costs. The highest award to date for pure sunshine, Venice was sunshine and public record, pure sunshine, The Burt Fish Hospital Authority paid $1 million in attorney's fees and court costs. $1 million. $500 fine. Okay, we're gonna take, don't look at that clock because it's not moving. It's 10:30, we'll take a 10-minute break and then we'll come back